Morning, everybody. I think we can start. I know there's about 250 registrants, but you're about 99 at this point. So let's start. Just hold on. So welcome, everybody. I just want to tell you about the logistics of this webinar. We might have technical issues or anything like that. Please bear with us. We are attorneys and fortunately not very technologically advanced in that regard. Well, I am not. My colleagues luckily are hosting it, but we'll see how it goes. Also, apologies for any noise interruptions or something. I seem to have a flock of haridas that have taken up residence in my garden sometimes, so just bear with me. There is a Q&A tab. If you could please direct all the questions to the specific window, and I'll address them at the end of the seminar in order to keep it as quick as possible. So my name is Anja van Wijk. I'm a senior associate in the Property and Municipal Law Department, and I specialize in evictions. I've done evictions now pretty much hands down, landlord-tenant issues and evictions for the last 7 years, and have done anywhere between, I would guess, around 500 evictions so far. I also have one of my colleagues in the seminar. His name is Mark Squy. He's Mark Gevers. He's a Canada attorney in my department and might be assisting here. Now, I'm going to talk a lot about residential versus commercial because they are so different in terms of the contracts. Residentials tend to sometimes even be not in writing and verbal and tend to be quite easy compared to commercial. They tend to be more drawn out contracts. It's also because it's different in the case that residential tenants are currently occupying the properties, while commercial tenants, a lot of them have now closed down. And even though technically occupying the properties, are no longer trading from those properties. So, want to make it clear from the beginning, I do not condone non-payment of rental. In 99% of the cases, we foresee that rental will have to be paid by the tenant. There is a very small % chance that a tenant will get away with not paying rental. Essentially, if people don't pay rental, then the property market and pretty much the economy will collapse. So it is not a case of where I will, advocate for the non-payment of rental. And because, this is my disclaimer, because we are in such unprecedented times at this place, we find that we don't really know where this is going and how the courts are going to deal with this. But looking back on case law, dealing with similar but not the same situations, this is how we think the courts are going to deal with this. So, like I said, this is strange and unprecedented times. Commercial tenants are advised to close up shop and they can't trade no longer, even though all of their possessions and all of their trade goods are in the property. And chances are that the commercial tenants will probably be hardest hit by the COVID outbreak. While residential tenants are different. Like I said, they actually have occupation of the property and they're inside the property. The problem is whether or not the subsequent circumstances of the COVID outbreak, for instance, retrenchments, could affect their income, and whether or not they would have enough income to pay their rent, and whether that rental would be paid to landlord, and whether that rental would be able for the landlord to pay such expenses like repairs, mortgage bonds, utilities, levies, and accounts. Now, we've seen a lot of things in the news lately. There was one that started with a proclamation apparently by the deputy health department. I don't know what they would have to do with property law, and somehow has barred any landlord from collecting rent. But that is false, absolutely false. We've also seen major corporations like Edcon saying that they will rather pay their salaries, their employee salaries, and pay rent. Foschini Group has also threatened not to pay rent. So we are seeing a massive dive in commercial tenants and seeing that they are putting their foot down and saying they will not pay rent. This is a huge concern for any kind of property department. They also released statistics a few days ago, which said that last year this time, non-paying tenants were roughly around 6% of the populations. It is now increased this month alone to 16%. There are 16% of the tenants that don't pay rent at all. Now they're saying as well that about a third of the tenants are only paying partial rent this month. And obviously this is a big concern because next month is obviously going to be even worse. Then on the 28th of March, the Minister of Justice released a regulation, gazetted it, which stopped all executions of evictions. So this means that any evictions, whether lawful or unlawful, whether you're trying to lock them out and so, or not, is stopped. There's a moratorium on evictions, which means you cannot execute an eviction once it's granted, or you cannot try to evict anybody at this point. But that doesn't mean that you can't lay the basis for an eviction. You can pretty much still send out, if they're non-paying or late paying or anything like that, you're still perfectly entitled to send out letters of demand and send out cancellation letters. And in a few weeks, hopefully, some of the restrictions on the courts will be lifted and we'd be able to apply for the eviction. The eviction just cannot be granted, cannot be executed during lockdown because people need to stay at their homes. Essentially, what we're getting is a lot of queries regarding movements. The tenants said they vacate the property at the end of March, and lockdown was enforced before April, and now they're stuck. The thing is, they cannot move. You can only move with groceries and going to the pharmacy for your medical aid. You cannot move anywhere else. If anybody does move, they may face criminal charges. And coming from the criminal department, we've seen a massive spike in people getting arrested for unnecessary movements. We are doing bails pretty much on a weekly, if not daily basis. I don't want any tenants in this regard to take that risk. If you are in lockdown, you are in your house, you have to stay there until lockdown is done. There's no moving companies currently working. They're not considered necessary in this regard. There's also no ingoing and outgoing inspections or property viewings. So if your tenant is stuck in your property, unfortunately, until lockdown is lifted or the restrictions have at least been eased at some point, they need to stay there. All right. So over the last few weeks, we've heard a lot about force majeure. It is actually an centuries-old concept, and it is based on our common law. Now, common law comes from centuries and decades of law. This is usually based in case law, and it is not brought by legislation. So it is very vague. That is the main issue about force majeure cases. So if a tenant does not effect payment or does not effect it on time or makes only partial payment, usually that would be a breach of the lease agreement, and you would then send out a letter of demand, giving them a certain time in which to remedy that breach, whether it be a CPA 20 business days or in the lease agreement 7 days if it's not a CPA lease agreement or whatever. After that, you can cancel the lease agreement, demand that they vacate. Obviously, if they're in the property during lockdown, they still need to be there until you can get an eviction order granted or they move on their own accord after lockdown. So that would be in normal circumstances. But force majeure, they also call it a causa fortuitas or vis mea, or an act of God, is an extraordinary event or circumstance which is outside the control of the contracting parties to the agreement. In certain situations, a force majeure can cause the agreement to become impossible to comply with and then can potentially extinguish the obligations of the landlord and or the tenant. So that would be the general idea of it. This is a quick overview. Now, Common law would be our default situation. This would apply in most cases. I'll deal with when there's force majeure situations in a clause agreement, in a clause in a lease agreement. So common law has these crazy requirements which need to be fulfilled for you to say, this is a force majeure, and this force majeure has now prevented me being able to pay my rent. Firstly, the impossibility must be objectively impossible. It must be an absolute as opposed to a probable impossibility. The impossibility must be absolute as opposed to relevant. So for instance, if my tenant can pay, or if my neighbor can pay, but I can't pay because of outside circumstances, like for instance, retrenchments or cuts in my salary or something, that does not make the impossibility absolute. Another thing is the impossibility must be unavoidable by a reasonable person. It cannot be the fault of either party, and the mere fact that a disaster or event was foreseeable does not necessarily mean that it ought to have been foreseeable. Now, going through the requirements, you can see that it is absolutely vague. It is hard to apply in any case, and you have to look at the case-by-case basis. And we have this problem in common law because this list of requirements is not a closed list either. And because it is so vague, and you have to rely on each facts of the merits, and it isn't an overbranching view, a lot of people rather contract or have contracts that deal with these situations, and we call them force majeure clauses. Now, they say that natural disasters, strike action, or acts of states are generally accepted as force majeures. However, just because it is a force majeure does not mean that a person cannot pay their rent, for instance. It is pretty much accepted that the COVID-19 outbreak is indeed a force majeure. However, it does not necessarily mean that just because it is a force majeure, I cannot pay my rent. So you have to look at the outside circumstances as well. Again, I'm sorry if it's very vague, and this is the problem with the situation. So in order, like I said, in order to avoid this default situation in the common law, a lot of people have put in their own provisions to make sure that their force majeure is defined, what is considered a force majeure, and in what circumstances one of the parties is entitled to avoid their obligations. Now, we can see a lot of force majeure clauses in commercial agreements, while in residential agreements, they're less often seen. Residential agreements, if they do have them, tend to be very limited, usually limited, for instance, to a fire that burns down the whole house or a portion of the house, or a flood that floods one room or maybe the whole house and takes it away. These would usually be outlined in the agreements. Now, if you do have a written lease agreement and there is a force majeure in that lease agreement, a landlord and a tenant should review the leases in order to see, is there a force majeure provision? If there is, does it apply to the COVID events we are going through right now? If it does that excuse the performance by the landlord or the tenant or both? If it does it permit a party to terminate the agreement? If so, is the landlord entitled to immediately terminate the lease agreement? And the second one would usually be a notice period. There might be a clause in that lease agreement, in that force majeure, that says you have to give a certain time notice. For instance, you have to give your landlord 7 days notice that COVID has made the performance impossible, and therefore I can no longer pay rent, for instance, and therefore you need to do what you need to do. In that case, usually the landlord would then send a letter of demand or deny the force majeure. Now, like I said, in most agreements, there are force majeure, or some of them at least, there are force majeure clauses, but they tend to be very general. It usually is a very vague saying an unexpected or unavoidable government act will qualify as a force majeure. Because there's a government mandated quarantine and restrictions, we can say that, yes, this is a force majeure. This situation, especially for commercial tenants, talking about commercial tenants, the COVID-19 outbreak could be considered a force majeure, which could prevent its performance. But that tenant who relies on the fact that this force majeure is preventing payment of the agreement, they still need to satisfy the majority of the requirements of the common law, which, like I said, are so vague. They firstly need to say that there is a force majeure, and secondly, that the force majeure has caused the impossibility of performance. It can be argued that although, now this is, I actually sat on Facebook yesterday and on all the news outlets and on all the legal forums yesterday, trying to figure out what other attorneys think about whether or not, especially in commercial agreements, whether or not this force majeure could prevent performance. At that case, sorry, just excuse me. Like I said, I was sitting in that forum and trying to see what other legal opinions and minds had. And a lot of them would say, absolutely, force majeure is in place for commercial tenants and payments not rent. On the other hand, about 60-70% said no. The only situation in which could prevent payment would be, for instance, if the banks collapse and you could no longer transfer money, or you can no longer go to the ATM and get the money out of there. Because even though payment is difficult, it is not impossible. And the courts, we foresee, would differentiate between impossibility versus a difficult situation or undue hardship. Even though payment is difficult, it does not mean that it is impossible. And that is pretty much how we foresee it, that tenants will still have to pay, even though it is difficult, it is not impossible. And these tenants cannot therefore rely on the fact that the force majeure has caused the impossibility of the rental payments. Now, we have seen in very few cases, I've seen thousands and thousands of lease agreements throughout my life, and pretty much some of them, saying a handful, I have seen a very specific clause in that lease agreement. So after the SARS and MERS viruses caused some endangerment to global health, some contracts have included this threat in force majeure clauses. They would include, for instance, the word of disease, illness, pandemic, or epidemic in the force majeure clauses, stating that these would constitute force majeures and will prevent payment of the rental. If that is the case, and the lease agreements have these specified four-sided clauses, then chances are very well that COVID-19 has triggered those. But they would also then usually say what the consequences are. For instance, the lessee would be entitled to rental remission, or sometimes even no payment whatsoever. But again, the impossibility needs to be proven as opposed to just a difficulty. Now, if the tenant decides, okay, this force majeure clause is acceptable, and this COVID-19 epidemic and the force majeure has prevented the payment, and it has been triggered, if they make that declaration and it is not the case, then the landlord can accept that declaration saying he's not going to pay as a repudiation of the lease agreement. And if the landlord accepts that repudiation, it could open up the tenant to damages claim and everything else. So it's very important that if a tenant relies on the force majeures and possibility to affect payment, that they make 100% sure that that is exactly the case. Therefore, we suggest getting legal advice. Just don't do it on yourself. Also, check the time limits. For instance, if you had instituted the force majeure impossibility a month ago, which would have been an easier situation. Meanwhile, if the lockdown ends in another month or two, and there was only a 2 months limit on that implementation of impossibility of performance, then you would be struggling. So you have to also decide if there's a time limit in the clause and whether or not that time limit is a good idea to implement now or later on, considering that we'll probably be in lockdown after April. So the party seeking to rely on that clause as a force majeure to prevent payment of the rent needs to prove it. It is not up to the landlord to prove that. And that creates such a difficult situation for the tenant to consider and present regarding payment of rental. If the lease agreement does not outline the force majeure, what would constitute a force majeure, and what would allow the tenant to rely on non-payment of rental is not in the lease agreement, then common law would apply. And like I said, it's very vague, it's very difficult to prove, and you would have a problem proving impossibility versus difficulty. So is COVID-19 pandemic a force majeure? Yes, it is. Naturally, it is generally accepted that these are natural calamities, and acts of state and strikes are force majeures, especially acts of state in terms of commercial property because they've been asked to close their doors, but not in terms of residential tenants because they're still sitting inside the property. So if a residential tenant still has occupation of the property and has utility service and has the physical ability to pay rent, i.e. EFT payments to the landlords are still operational, then residential tenants in all likelihood, and I'm saying about 99.9%, cannot escape their liability to effect payment. They will be held towards the obligation. So, yes. So at this point, where are we? It's generally considered, especially among property practitioners, that COVID-19 should be considered a humanitarian issue. So landlords and tenants need to work together. Tenants need to specifically take proactive steps in order to ensure that payments made of rental. If they cannot make payment, they need to advise the landlord immediately. And the landlord can then take steps either to say, okay, I want it or the rental, which I have not seen much, but in my opinion, that they have to agree to possibly a rental reduction, or for instance, using the deposit towards the arrear rental, or possibly a deferred payment. I suggest that all of this is in writing. But the landlord and the tenant have to agree, and it's not up to the tenant just to decide what he or she wants to do. They will be held up to the obligations of the lease agreement until such time as it is proven that this force majeure has caused the impossibility of performance. For commercial tenants, obviously, this would, in order to mitigate the risks, would include seeking alternative income. Retrenchments, unfortunately, is something that we are dealing with on a daily basis at this point. Applying for relief measures announced by the government, cutting expenditures, and if necessary, putting the business in business rescue, or even the worst case scenario, a liquidation of the company. Now, if a tenant does rely on force majeure and is successful stating that the force majeure has caused the impossibility of payment of rental, then the obligations earned between the landlord and the tenant are extinguished, and the landlord can take repossession of the property once lockdown has occurred. The landlord would then not be entitled to damages, which is also included any kind of damages regarding vacating of the property, or anything like that. So landlord would, on the only situation, be entitled to unjust enrichment of the tenant if it turns out that the impossibility was not absolute and was not objective, in order to that the tenant actually could perform and pay rental. So that would be pretty much equate to kind of a rental claim in that regard. So, like I said, all evictions are currently suspended. The execution of eviction is suspended, not the basis of cancelling the lease agreement and so on. That is not suspended, and you can still send out letters of demand and cancellation letters and so on. We obviously expect a massive increase in both commercial and residential evictions once the lockdown is lifted. So what we can see is with commercial evictions, there's no requirement of justness and equitability that the court needs to take into consideration when granting the eviction. So therefore, we can see that in commercial evictions going forward in the future, the commercial evictions really should not be delayed whatsoever. While in residential evictions, we can see that definitely the financial impact that has come out of the COVID-19 issue will definitely be taken as a factor that the court will decide in the future once lockdown is done, that the court will decide on whether granting of the eviction is just and equitable. For instance, if the tenant has lost his job or been retrenched, or is a small business and business couldn't trade, that is very much a factor that the court will take into consideration when granting the eviction. But in practice, in evictions, the court will not try to, what it would equate to expropriation of the owner's property. All they would do in practice, and what we would foresee, is that they would give the tenant further time in order to vacate the property. That means that evictions, residential evictions, and getting occupants out of the property will be delayed. In this regard, that is why I urge landlords to address any non-payment or late payment of rental with the tenant as soon as humanly possible and not wait too long, because at that point, you're losing a few weeks here and a few weeks there. Once you start the eviction process and actually get the eviction granted a few weeks or months from now, they would even get further time in order to vacate the property. So pretty much this is our summary and what we conclude is going to happen. We conclude that all tenants should anticipate having to effect rental payments. We also think that in commercial leases, if the force majeure clause is sufficiently worded, the tenant may be able to raise COVID-19 pandemic as a force majeure and therefore escape liability. Again, the tenant should, in this case, seek legal advice in order to ensure that this is absolutely has affected the inability to perform and then provide proper notice thereof. Now, because if the lease agreement is not sufficiently worded and the force majeure clause is not sufficiently worded, the common law will apply. And the common law is so ambiguous that very much there's a massive likelihood that the commercial tenant will not be able to escape their liability to effect payment. While in terms of residential tenants, it is highly unlikely, if not impossible, for the residential tenant to escape their obligation to effect rental. But because of the economic backlash of COVID-19, chances are very high that the courts will then consider the economic impact of what is going on months down the line and take that into account when granting an eviction application. And chances are very much that they would then provide them with more time in order to vacate the property. So pretty much, guys, that's it. I'll address now any queries you will have. Just hold on. Just need to see there's quite a few. But if you have anything other, you're welcome to email me, and my number is there. if I don't get to you at this point. So it says, just direct your questions to the Q&A. If you're not interested, you're welcome to leave, and it was very much a pleasure to talk to you a little bit about it. So any movement, like I said, this person is asking regarding the movement of the domestic worker. Unfortunately, during lockdown, all people need to stay there. They are obliged to stay there. And if they don't want to move and they say, I don't want to move, then the landlord's not entitled to make them move at all. If you make the move, that's an unlawful eviction. And chances are you'll probably be locked up, if not face criminal charges. Any attempt at an unlawful eviction is a criminal offense. Another question is a landlord that cancels your management agreement in the middle of lockdown and enters directly with the tenant for new lease agreement. Obviously, the landlord's trying to mitigate their charges for the management agreement. I'm pretty sure your management agreement should cover that, an early termination clause, and it would usually allow the landlord, the property manager, a cancellation fee. Other than that, but landlords are entitled to cancel their management agreement. That is according to the CPA. Hi, what do you do when a situation where a tenant is getting 50% of their salary and cannot meet their payment obligations fully? Unfortunately, the situation in that regard is approach your landlord immediately. Say, I can only pay this much this month, and we'll see what I can pay. But you have to keep an open channel between the landlord and the tenant. This would make the tenant a lot more, or the landlord a lot more obliging in terms of negotiations and so on. So, the landlord can agree to, for instance, use your deposit with you, usually. The landlord would then or reduce your rental or do a deferred rental agreement. But unfortunately, the tenant will be liable for that. If you want to cancel your lease agreement, usually in a CPA lease agreement, the tenant can give 20 business days notice of the termination, whatever the reason is. Landlord can't do that. Like I said, when tenants' moving days was lockdown, the tenant is in occupation of that property. And even though they had to move past lockdown, they will be liable to that for that rental until such time as they vacate the property. Another question. Respectfully disagree that we can look at lease and contracts as if normal circumstances. This worldwide situation would create some new circumstances, and any contract is only valid as the law of the land and be the current circumstance. After all, PI requires all relevant circumstances. Absolutely agree with you. PI requires all relevant circumstances. And your inability to pay because of retrenchments, for instance, is something definitely the court will take into considerations. They've always done that. But a court will not expropriate a property. Rights overridden, contracts, responsibility, ability. Well, I'm not sure what you're asking. A forced situation, obviously, is a difficult situation because it could be an attempt at an unlawful eviction or a kind of extortion of some kind. But unfortunately, the obligations stand. I cannot see any courts agreeing to let all residential tenants off the hook. It would cripple the entire property market, which is the cornerstone of any economy, and would absolutely break the economy at that point. I'm not sure what the guideline is relating to student accommodation, but if you're in the property, you have to stay there. That is it. You can't, there's no movement. They can try to evict you, which is clearly unlawful. And if they do try, you get an urgent spoliation application to force yourself back into the property, and the landlord will have to comply. The courts are doing a lot of these at the moment. The statement is difficult but not impossible is broad and hardly applicable to the masses, many of whom do not even have money for food, let alone rental. I completely understand that. Again, my opinion, and like I said, some attorneys differ in this regard. I do not believe that that people will be able to stay in the properties indefinitely, and they will be held to at least some form of their rental obligations. If they get retrenched, unfortunately, after lockdown, they will probably have to move to a less expensive property. Excuse me. In the case whereby a tenant does not pay rent, can we request the tenant provide proof that his or her salary was not paid, and we demand that the tenant provide with bank statement to prove that no. You can obviously ask any tenant if they are, especially if they're bona fide, to provide you with their salary slips, proof that they haven't, or their bank statements, proof that they haven't been able to make payments. And this would be obviously make the landlord more inclined in order to give the tenant a little bit of lenience. You can ask for it. If the tenant does not apply, does not wish to give that bank statement or salary slip, then unfortunately you cannot force them to do that. And chances are they're not extremely bona fide in that case. And chances are then that the landlord will not be more willing to enter into any kind of negotiations regarding rental remissions. If my tenant offered a partial payment, I am in no position to accept. Do I have to accept? No, you do not have to accept. But you need to mitigate your risks as much as humanly possible. If they can make a partial payment, at least it's some payment. And if they give you bank statements and salary slips, then at least they're bona fide in that regard. Going through the rigmarole of having a non-payment and then having to evict them at a later stage and paying all those legal fees, well, chances are you're never going to recoup any of that rental that you've lost, is slow. So you need to consider whether you'd rather want to accept a partial payment now or months from now, pay an attorney, try to get the occupant evicted while never seeing any of that money that is owed to you. What is your opinion if a tenant is not in occupation during lockdown, lost all their income altogether? If a tenant is still liable for their rental, then they would still have to pay it. Chances are they probably have to cancel their rental and then they don't even need to move out. But I would suggest sending a letter of demand so that you can cancel the lease agreement and get a new paying tenant in and mitigate your damages as much as possible once the lockdown has been lifted. This is all about mitigating damages, guys. A commercial tenant informing the landlord that they would accept pay this rent this month. If they don't give reasons why they're not paying rent, it could possibly be seen as a repudiation. But again, I suggest you get legal opinion on this because it's up to you whether or not you decide to accept that repudiation or not. If you still want to hold them to that lease agreement, you don't accept it. So I do suggest you get legal advice in that regard. Can the month of April be included in accounting for penalties for a tenant who cancelled their lease agreement early? Say they moved out end of March, and their lease says we can charge 3 months rental penalty for cancelling early. This is usually the reasonable cancellation penalty in terms of Section 14 of the Consumer Protection Act. I don't suggest you charge 3 months rental. Chances of you ever seeing that is you can invoice it as much as you want, but there is no court case that says what is considered a reasonable cancellation penalty. In practice, a lot of what these landlords do in early termination clauses is hold on to the deposit. But chances of you being able to get through the Rental Housing Act or being able to sue for those three months is slim to none. What you can do is, for instance, sue for damages if you weren't able to obtain a new tenant as soon as humanly possible. Do the landlords have a right to charge interest on deferred payments? Well, I would put that in a deferred payment agreement if you do decide as a landlord to accept the deferred payments. If it needs to be in an agreement, you cannot charge unless it is in the agreement. For instance, bank charges or anything like that, if it is not in the agreement. So unfortunately, that's with that. Commercial example, your lease has come to an end and you are open up after lockdown. What claim does a landlord have to? Your lease has come to an end and you are open up after lockdown. What claim? Well, it would be the rental that was agreed upon. So even though you might not be trading from the property, chances of you avoiding your rental payments is small. Terms of occupational rental to be paid, transfer of property. OTP states that purchaser shall be liable for it from first name. Necessarily, purchaser cannot take occupation. Well, occupational rental relies on occupation. That is a difficult situation because we would have to see the sale agreement and see what exactly is the requirement in terms of occupational rental and when exactly it would be due. Again, I would have to see the lease agreement. In terms of residential tenants, if they cannot pay rent during this time, they cannot be evicted. But the landlord is entitled to sue for the rear rental, therefore the tenant remains liable for the real rental, if any. Yes, that is our opinion. Can I follow up on payment with tenant if I cancel the lease before lockdown but tenant has not moved out? Yes, you can. What I do suggest you do is not use the word rental, because currently they aren't necessarily tenants. They are occupants, unlawful occupants, because they no longer have a right to reside there because the lease agreement was cancelled. Therefore, if you want to, you can say occupational rental or damages or rental damages rather than rental, because if you demand rental, you may be subconscious tacitly reinstating a lease agreement that has already been cancelled. So yes, you can, because they're an occupation of your property and they should be paying occupational rental or damages as opposed to rental. But yes, absolutely. So if the landlord gives notice to a tenant to terminate lease, but he cannot move out, is the tenant still liable? Yes, that is still liable. He's still in occupation. He has to pay for his occupation. If the tenant cannot afford it, can the landlord claim it later on? Yes, you can. But I do suggest you enter into negotiations with the tenant and see whether you could come to some kind of agreement regarding a reduction, which would cover your expenses, but also not make it so difficult for the tenant that it absolutely destroys him or her. On the question of student accommodation, can the landlord still charge for rent even though students are not in residence? I would have to see the lease agreement, but like I say, if it's like if you are on holiday, do you still pay your student accommodation? If so, and your stuff is still in there, and the landlord can't get another tenant in to replace you, then like in a holiday, you still have to effect rental. But again, I would have to see the lease agreement. Student accommodation tends to be quite tricky because they tend to work very much under the law and they tend to be a little bit more dodgier. I know they lock out students all the time. If a residential tenant's lease expires end of April, lockdown extends, must the tenant leave on 7, or can they argue that they stay until the end of May? If they, for instance, effect payment of rental in May as opposed to pro rata payment, then they can stay up until May, especially if you don't have a new tenant coming in. Why not let them stay longer? But if you have a new coming, I highly doubt it that you would have a new tenant staying in. And a lot of the times, lease agreements start on the 1st and end on the last day of the month. So it would be very difficult to get them out. But I would suggest that they do then effect full payment of the rental as opposed to only the pro rata amount for the 7th of May. My tenant has not paid for several months. We managed to get a court date set for the 16th of April, which of course didn't happen. If in May this case is heard, can the tenant use COVID as a reason to have the eviction delayed, taking into consideration that payments stopped long before the outbreak? No, especially if the lease agreement was cancelled prior to COVID. But what they can do is put their personal circumstance before the court and say, this is why I will be rendered homeless if the eviction is granted immediately. Usually in that case, they would get, instead of a month in order to vacate the property, they would get from the judge, for instance, 2 or 3 months. This is what we're going to see going forward, even though your eviction was set down already prior to COVID happening. A landlord hasn't been willing to accept any negotiation. The tenant has a 2-month cancellation clause in the agreement that would avoid going into further debt. Would you advise the tenant cancel now and incur the 2-month rental penalty? If a lockdown is prolonged after 2 months, would they still? If the lockdown is extended, unfortunately, the tenant will be liable for that. Like I said, with regard to the reasonable cancellation penalty, these 2 months and so early termination cancellations, it would be hard for any landlord to claim that if you don't pay it over. They would then have to go to a rental housing tribunal because usually legal fees are just too expensive in that regard. So I would rather cancel if chances are very well that you cannot pay rental, because at some point there will probably be an eviction against you, and in that situation, the situation goes from bad to worse to absolutely horrendous. Absolutely. In the event of non-payment of rent, would you suggest an AOD? Absolutely. An AOD is perfectly fine. Just make sure everybody signs it. But other than that, that is a perfect way to try to mitigate damages, keep your tenant in, not have an eviction application, not have to pay me an exorbitant amount of money in order to get them out. Yeah. If a tenant's paid it, I'm getting hundreds. If a tenant has paid a deposit in first month's rent on a new rental and cannot move on the agreed date and has to remain in the present property, would the tenant be liable for double rent? I would not say so, just because it is just not fair. They would be liable for the rental of the property that they are occupying. But again, we don't know how the courts are going to see this or how the rental housing tribunal is going to see this. But chances are these matters are going to go a lot to the rental housing tribunal. And the rental housing tribunal is very much pro-tenant as opposed to pro-landlord. A landlord took house keys from a tenant due to non-paying. Tenant asked to remove furniture and landlord says no. A few days later, some items are missing. Tenant informed, and now tenant demanded agent must pay, but agent no. Landlord has opened a police case. Okay. Landlord's clearly unlawfully evicted the tenant. The tenant asked to remove furniture. Landlord says no. The tenant is perfectly entitled to open up a police case, because unless you have a court order saying these items in this property are subject to my landlord hypothec, the tenant's allowed to move them. So clearly the agent has no deal with this, and there's no relationship between a tenant and agent. There's only a relationship between agent and a landlord. And the tenant absolutely has to go after the landlord for that. Yeah, the agent should not be involved there. If you buy a property through a sheriff, do you have to pay occupational interest during lockdown? Is there any way we can waive a month as the transfer is also delayed? I would have to look at the sale agreement that you concluded with the sheriff. I'm not sure what it says. Again, I can only give you general advice. I can't give you specific advice especially if I haven't seen the agreements signed. How long does an eviction take to execute at the point of tenant leaving the property? Okay. So you're pretty much asking the time periods in evictions. It really does depend on usually the court and whether or not the occupant decides to oppose the eviction. So if you are in certain courts, for instance, Pretoria North, Randburg, Krugersdorp, Roodepoort, you're looking at about 6 to 8 weeks from the initiation of the, issuing the application and serving it on the occupant up until the granting of the eviction. Then there's usually another month after that the judge will give in order to vacate the property. That's in a case of an unopposed eviction. While an opposed eviction can take anywhere between 3 to 9 months, sometimes even longer if you're looking at, for instance, court recess and something like that. So that is, in my experience, how long it takes. The eviction is ready to move at the end of the lease on 30th. If lockdown is enforced, what do we do? Can the Lord? Yes. If they are still in occupation after lockdown has been lifted, then chances are that that tenant will be liable for that rental until such time as they vacate the property. If residential tenant still has property but has left to go home for lockdown, can rent be withheld? No indication of cash. No, especially no indication of cash flow. If this stuff is still in there, rent can't be withheld. They cannot just say I won't pay rent just because I'm not there. That would be unfair. If I decide to go on lockdown with my family, for instance, and leave my flat open, I would still have to pay rent for my flat, of course. Would tenant still be liable for rent if he has possession of the residential property but has decided to move to another premises likely to? Yes, absolutely. Same question as before. They would still, if they're still in occupation and they just decided to go to the family, they would still have to pay those. If tenant can't pay, do you have to give them a month's grace and waive rent? Can we use their deposit? Would it be better to waive rent to have good relationship with tenant? I would rather enter into negotiation with a tenant than go through a very expensive, very time-consuming and stressful eviction situation. They tend to be very expensive. So in that case, and very time-consuming, during that time, you usually then lose rental at all. So you decide. You don't have to give them one month's rental, but possibly speak to them, say, can we use rather your deposit, and then you pay back your deposit a portion at a time 6 months from now, and negotiate, guys. Negotiate with your tenants. A commercial tenant's claiming supervening impossibly as they cannot access the premise. Is this a valid reason not to pay rent? Like I said, it really does depend on the force majeure clause in the lease agreement. If it is very general and does not, for instance, specifically related to illness or pandemic or epidemic or virus or something like that, then our opinion is that 99% of the time they still have to pay rent and they cannot use COVID as a supervening impossibility. Well, I think that's it, guys. Thanks so much. If there's anything else, let me know. Otherwise, you have my details, and I'm sure I'm going to get quite a few questions further on, and I might refer some of them to my CAN attorneys, but they are very much very clued up on the matters. No problem, guys. Oh, there's more questions. What notice period is applicable where no contract is in place? If you have to look at the breach clause, if they're on breach of the lease agreement, you usually give them 7 days in order to remedy their breach. That's in terms of the Rental Housing Act. If you entered in, you have a verbal agreement. You say, okay, you pay 7,000 Rand. Cool, no problem. How long are you going to say? A year. So if it is a fixed term, then you have to give them 20 business days notice in terms of the CPA. If you are just on a month-to-month basis and there was no time limit, then and they haven't breached, then you give them a month in order to vacate the property, saying, I'm not going to renew this lease agreement after the month has then finished. No, well, that is a difficult situation. Can a tenant force a landlord to take a lease extension? It really does depend on whether or not the CPA applies. So in terms of Section 14 of the CPA, if it is a fixed term agreement and that fixed term lapses, for instance, at the end of April, if a landlord does not want to extend after that April, they have to give the tenant notice no more than 80 business days and no less than 40 business days before that ending of that lapse of that lease agreement of their notice not to renew. If, however, the period is now in March and the tenant says, I want to renew the lease agreement, then it will not it may renew, but possibly on a month-to-month basis. So just to confirm, if a commercial lease agreement has a force majeure clause, but that clause does not specifically refer to an illness or pandemic, then they're still required to pay rental. That is, in our opinion, correct. Chances of them being able to prove the force majeure or cause the impossibility based on the common law requirements is very small. All right, guys, I think that's it. Great, thank you. Have a good day.